Hey YouTube, my name is Natalie. I'm a criminal defense attorney. Welcome to my channel. Thank you so much for checking this video out. So today is going to be a reaction to this person's multiple court appearances with a judge that seemed to be pretty contentious. A few of you guys sent this to me in my email. Thank you so much for the suggestion. We will be picking up part 2 of the Darius Cook's saga investigation videos very shortly, but I wanted us to have kind of something different in the meantime. And a reaction video because it's been a while since I've done one and I really enjoy reaction videos. So let's get right into it.
Permitting a motor vehicle to run unattended, there's a violation, but disorderly conduct is a B misdemeanor. There's a maximum fine of $250 and or up to 90 days in jail. How do you want to plead?
Not guilty. I can be appointed lawyer, public defender.
You have a picture on. You got a full-time job. That's for people that are on.
Excuse me, I can't hear you.
You have a full-time job.
I don't have a job because
Well,
of
then you
it.
need to get one. You're not on disability, so you'll have to get your own attorney.
But it serves
Plus, I
time.
don't think you were offered diversion, so I don't think he's going to.
Because I'm
There's no
innocent
jail
till
time.
proven guilty.
Neither charge qualifies either way. It's something that's $500 or more and or up to,
Which I need some time to get my witnesses and all that.
Okay, very interesting. So I'll have to look and see what state this is, but this person is requesting the services of a public defender. He has a charge of disorderly conduct, which carries a maximum $250 fine and 90 days in jail. The judge says that in order to qualify for a public defender, you have to have at least a $500 fine, and then he cut her off before I could hear her say how much time in jail. And then she goes, well, anyway, you were offered a diversion program and you turned it down, which is completely his right. So a diversion program is usually a program in which the person avoids pleading guilty in exchange for doing something. So they could have to do community service, do drug treatment, take anger management. There's a bunch of different type of things that a person could be ordered to do depending on the type of diversion program that it is. There's drug court, there's mental health court. So he was offered a diversion program and turned it down, which is totally his right. But I think what the judge is saying is that statutorily he's not entitled to a public defender in their state. In my state, people are entitled to a public defender for any charge that faces jail time. And I haven't checked this in a while, but I think this may still be the case for traffic citations that carry more than $500, even if they don't carry jail time. I think you also can qualify for the services of the public defender.
I'm going to put it through a pretrial first. Sure.
So he has multiple court appearances in front of this judge.
Phillips, will you state your name, date of birth for the record, please?
Eric Phillips, 11/20/80.
Judge, I've not pretried the case with Mr. Phillips. Our offer on a plea of guilty to disorderly conduct would be 45 days, probated for 2 years. No further offenses, pay court costs.
I would like to.
So they're offering a jail offer from diversion to jail, which they're offering 45 days and to pay court costs. Interesting.
Request for a public defender. I got an affidavit as well.
You have a full-time job. You
I don't have a job, ma'am. You're not even giving me a chance.
I'm sorry, Mr. Phillips, you don't qualify.
Well, I'd like to have a continuance for pretrial, please.
Continue the pretrial.
Do you have the motion for discovery, or do I got to give you
That's what
a?
you're here today for, okay?
So you got it already?
You have to do it.
I turned it in Friday.
He has whatever discovery, he
You got it?
probably has it today.
I got a copy.
Okay. So,
Who I get it?
I'll go ahead and set it for trial then.
Could I get a continuance for pretrial so I can
Okay,
get
I'll continue the pretrial August 20th, and that'll be at 9 o'clock back here.
all right?
Okay? He refused the version.
Yeah, because it's innocent until proven guilty.
This is edited, and I kind of have an issue with that because there's a whole different person now that she's talking to, and she's saying that he refused diversion. Again, that's his right to do that, but a diversion program doesn't contemplate a guilty plea. Or if it does, the guilty plea gets taken back at the completion of the diversion. So I'm a little concerned here that he thinks that by doing diversion, he's saying innocent until proven guilty. Of course it is. I'm concerned if maybe he doesn't quite understand that a diversion program doesn't include a guilty plea. Either way, he doesn't have to do that. He can take his entire case to trial if he wants.
Oh, no, but diversion is a program that
That's saying
you're not
guilty.
admitting guilt or you're
That's saying
but-
guilty.
She's telling you it's a program that doesn't include pleading guilty, and he's just telling her, the judge, that it does mean pleading guilty. I wonder if the judge and the defendant have appeared in front of each other before. It's very contentious.
I need that copy.
I don't have it. I'm going to send it to you digitally. It's going to come in 2 different emails. One's going to have some paper attached to it. The other will come from
The
evidence.com.
paper I just gave you is a copy.
All right. I'm trying to explain to you how you're going to get this discovery. It's going to be 2 emails. One will be from me. One will be from evidence.com. That evidence.com one will have the body cam link that you can download and save. Okay?
So you keep that paper?
Yes, it's a motion
So
for
what, I do go to the 3rd floor and get another copy?
I'm sorry. I'll have the clerk here make you one.
It's just his discovery demand. I mean, you should give them their own copy. You should have your own copy. And it's strange that they're not entitled to a public defender when they're facing jail time. That's very concerning. Very concerning.
Your email address on there. You can keep that. Wow.
Eric Phillips.
A different day, same case, same client or defendant, same judge.
Your name and date of birth for the record, please.
Eric Phillips, 11/20/80.
We're set here for pre-trial, I believe. The offer that was
We got 3 motions. One is to dismiss.
didn't get any motion.
Oh,
You didn't serve them on the Commonwealth, so
So, he's running into some issues here because he's proceeding pro se, and I get it. It's very tough to proceed pro se, meaning you're representing yourself. He has filed several pretrial motions. If this is set in on a pretrial hearing, usually at a pretrial hearing, especially if district courts do them, they're going to address preliminary matters like what's the plea offer? Has the discovery been provided? Do you have any motions issues to litigate? Some states will do that at a pretrial hearing, or at least docket them in for motions. In my state, they don't really do pretrial hearings for a district court. The trial date is the trial date. You're either ready to go or you're not. The state has either provided discovery or they don't. That's different in circuit court, where we do have pretrial hearings. We also have motions hearings that are set separately from the trial date. So that basically by the time you walk into trial, you know what evidence is or is not going to come in. It seems like he's filed a pretrial motion to dismiss, and he's failed to serve it on the prosecution. Because he's failed to serve it on the prosecution, the court can reject the motion, especially if it's not timely. You have to serve everything you're filing. You have to serve a copy on the opposing party. That's the same in criminal cases and civil cases.
that's ready to go. One is to dismiss, no probable cause, and the other is he wants to hear suppression hearing, and then the other is he wants a jury.
I don't have the Supreme.
Okay, so if he's moving to dismiss for a lack of probable cause, he's saying that there's no facts there's no credible facts that equal up to the charge that allege that he committed the crime in that jurisdiction on the date alleged, right? There's just no credible facts to that. Probable cause is a super low standard. Almost every single judge is going to find probable cause. Usually judges will not entertain a motion to dismiss for lack of probable cause in a pretrial hearing, because when they've considered release conditions or the person's been hit with their summons or served with a warrant or they've been arrested, probable cause has already been assessed. So by the time you're at the pretrial, the issue of probable cause is old. I don't want to say stale really, but it's an old issue, and it's no longer what the court is considering from then on out. Motion to suppress evidence means that some of the evidence was illegally obtained. That could be a search, that could be a seizure, that could be a statement, that could be an identification. And I didn't remember what the other motion was that he filed other than the motion to dismiss, so let's get right into it.
Suppression hearing or the jury demand?
Oh, he filed a request to put his case in to get a jury. He filed a demand for a jury trial.
Your Honor, there was a request for discovery, and that was sent by Mr. Reed. Mr. Reed had previously made an offer, so I would just ask to set it for...
Eligible for diversion, we won't take that.
So I would ask for...
She is so hung up on the fact that he's eligible for diversion and won't take it. I get it. Because diversion is such a gift. But maybe the person... Imagine, and you have to put yourself in the defendant's shoes. Imagine that a person is innocent of what they are charged with, and now they have to go to 40 hours of community service or 6 anger management classes or drug treatment or, whatever thing. It's almost like a punishment, even though the person's not going to get a conviction on their record at the end of the day. Now, if you have doubts as to whether or not you'll be found not guilty, or you believe that you are guilty of the offense, a diversion program is a gift. You're so happy for it. But people that truly believe that they're innocent, they want to have their trial. So stop bringing it up. She just keeps bringing it up. He keeps turning down. Because to the judge, it sounds crazy to turn down diversion. It's just really such a good thing to get. But in the perspective of the defendant, you have to listen to people. It's not a good thing if you're maintaining your innocence.
Or I guess a suppression hearing would be. So I need your jury demand. Thank you, sir.
What was that offer?
The offer that was made to you was 45 days, conditionally discharged, 2 years, no further offenses and court costs. That would be on a plea to disorderly conduct.
You said 2 years probation?
It's a non-reporting probation. It would be 45 days over your head.
Mr. Phillips, why don't you just go to diversion?
Excuse me, ma'am.
You were eligible for diversion. Why don't you just go?
Okay, so I see what the issue is here. The plea offer is not to jail. I was wrong. Everyone phrases things differently, but now that I listened to it, I was wrong. The plea offer is for 2 years of unsupervised probation, non-reporting probation. Stay out of trouble. Don't get arrested. Don't get convicted of any new offenses, basically. What we all should be doing. And you plead guilty, and then you'll just have 45 days over your head. As long as for 2 years you behave yourself, you won't get those 45 days. You'll be fine. In the alternative, you don't have to plead guilty. You can do a diversion program. You do the diversion program, you have no conviction. And so the judge is at a loss. I don't understand. Again, if he wants his trial, that's one thing. But why would you consider a plea offer that entails a guilty plea when you could do a diversionary program that has no guilty plea? But I will say this, in defense of this defendant, this is a state that doesn't give the right to an attorney to people that are facing jail time. And I think that's just wrong. He should, even if he had a job, attorneys are very expensive. There should be public defender access for people who make either a little bit of money or no money at all. Here he says that he's unemployed. He should get a public defender. He should be able to have an attorney to represent him. And I don't think that's fair.
Way, get it over with right away, and then you can get it off your record right away.
With no disrespect, because I'm innocent.
I'm just saying.
I'm
You want to...
innocent.
So, sir, did you want to take
I'll set it down for
set it
suppression. That'll be on...
So what about the dismissal? You denying that?
motion to dismiss is denied.
See, I figured that.
Well, what are your legal bases for your argument? I mean, really, it's not timely, the motion to dismiss. By the time you're at the pretrial, that's what the trial is for. I get a lot of clients asking me that, like, can't you just file a motion to dismiss? No, I can't just file a motion to dismiss. The court's not going to consider it because there's no legal mechanism to just dismiss the case after it's already been docketed for trial. Either the prosecution can dismiss it because they have the discretion to do so. It's their own case. Or you're going to proceed to a motions hearing where maybe evidence is suppressed, and because that evidence is not coming in, the case will be dismissed. Or it's going to be that you're going to take your case to trial and either be found not guilty, as you're presumed to be, or guilty.
And can I ask you a question, Your Honor? No disrespect.
No.
Okay.
No disrespect always is a bad sign.
Are you biased?
Really?
No, I'm just asking.
I've been on this bench. I'm the only woman that was here. You know what? Women have as much discrimination as you do, and it's even more.
I'm not talking about the color of my skin.
I now.
That's such a problematic statement because you're assuming he's asking if you're biased because of his race. And bias could just be, you just don't like me. Like, do you just not like me? And I always take issue when women, white women in particular, say things like, women face just as much discrimination as black people. You are forgetting that some women are black people. Some women are people of other races, Asian, Latino, Pacific Islander. Like, there are people of all types of races that are also women. But when they say women, they're saying it as though they're only talking about white women. Because actually, no, white women have not faced the same level of discrimination as black women or Asian women or Hispanic women. You haven't. It's not the same thing. Although white women have faced discrimination. But that's not what he appears to be talking about. However, I think it's inappropriate, or I don't think it's founded for him to say that this judge is being biased towards him. The laws are as they are written. He is not entitled to a public defender under the law of that state. It sucks. I don't like it, but that's what the law is. Just because she's telling you don't have the right to an attorney doesn't mean she's biased. No judge is going to consider a motion to dismiss at that stage of the proceeding because there is no legal mechanism for it. There's no case law or statute that supports it. And I think she's the opposite of biased because she's actually trying to walk you into not having a conviction on your record. She's trying to tell you, look, you don't need to have this conviction. Okay, you can have a completely clean record. Just do this diversionary program. She's a little too heavy-handed with it. I agree with that. But I don't think she's being biased towards him because of race or personality or anything else. I just think that obviously you've got your hackles up. You're a criminal defendant. You don't want to be facing these charges. You believe that you're innocent. You think that the entire system is against you. But the things that she's saying to him, I can foresee her saying to any defendant. Because the things that she's saying so far, from what I'm seeing, are legally accurate. And she could just say, all right, well, walk yourself into a conviction. I don't care. And not say anything to you, but she was trying to relate to him and tell him probably too much, that you can avoid this conviction. So I think that he feels as though he's not understanding the process, and that's why he needs an attorney. And it's what's not his fault is that he doesn't have access to one who can help him to make the arguments that he wants to make in the timely way that he needs to make them.
I do take offense.
I apologize. I wish
because
you
I
did.
knew you were going to since the day you came in. So I know what your plans
What is
are.
my plan?
You watch the news. I watch the news. Yes, it is. It
But
is.
what?
Forget everything I just said. I was totally wrong. She's a bitch. What does watching the news have to do with it? He didn't bring up race. You brought up race and said women face just as much discrimination. What women face just as much discrimination? What are you talking about? What are you talking about? Because to say women face just as much discrimination as him, a black man, excludes black women. It excludes black women. It excludes women of other races.
What are my plans?
Yeah. Just what you just said to me.
You just asked.
Suppression will be scheduled on October 22nd at 10 a.m. back here.
She took the bait.
You want to talk to an attorney?
I didn't hear you.
She said you may want to talk to an attorney.
Oh, okay.
He's doesn't have the money for one. He already said that.
I'll give you a reminder right here.
And he's back.
State your name and date of birth for the record.
Eric Phillips, 11/20, 1980.
Phillips, we're here today. I guess you have two motions. One for me to recuse. There's no affidavit, no substantiating anything for me to recuse.
Okay, but he's pro se, and if I were him, I would want to recuse her at this point in time too. Actually, completely, I'm going to keep all of this in, like all of my thoughts, because I think I read the situation one way, and then she revealed herself to actually be thinking something completely inappropriate. If an attorney asked her if she had a bias against their client, she would not be jumping down their throats, I would hope, yelling at them about how, oh, I knew what you came in here for. I watched the news. Clearly, you have been prejudiced by what's going on in the news as far as race is concerned, this did happen. This was uploaded in 2021. So whatever your personal issue is, I would want you to recuse yourself as well. And the standard for a judge recusing themselves should not be this formal. It's usually if there's the appearance of impropriety, and there is the appearance of impropriety. Again, I think the things that she told him previously were things that were based on legal issues. You know, you're not legally entitled to an attorney. Maybe she could have been a little nicer about how she told him. But either way, she wasn't telling him anything, wrong. Take the diversionary program so that you don't end up with a conviction on your record. And he has the right to say he doesn't want to take a diversionary program. For you to say, oh, I knew what you were getting ready to do. So that's literal prejudice. If you have prejudged this person because you think that you know exactly what he's going to do before he does it, just based on looking at him, you have prejudged him. It's prejudice.
Accused, I don't know anything about your case. You put it in your head of something, I have no idea, but that motion will be denied. I'm not.
She should recuse herself, and she's lying that she doesn't know about his case, because that, I don't care how long ago that was, you wouldn't forget having that interaction with him. I don't believe her.
I asked you, was you biased? And you confirmed that you was.
I'm not the least biased person you
I just got to the top.
And you know what? I'll send you to one of the other judges. What do you think? Judge Greathouse or Judge Eastland?
Doesn't matter as long as they're not you, because you're
The
biased.
motion to recuse.
She said, I can send you to one of these other judges, judge this person, judge that person. What does it matter? They're white people. She is making it terrible. It didn't have to be this way. Literally, I wasn't even thinking, until she said race, I wasn't even thinking that he was saying you're biased because of race. That's not what I thought. I thought maybe he was saying you just don't like me. And she jumped to, oh, it's race, and oh, you're gonna get a white judge anyway. So what does it matter? So it's denied. You could dislike someone and be biased towards someone on an issue that's not just race. And just why would you want to keep someone as a defendant in front of you when it does look like race is the primary thing that's on your mind, even if it's not the primary thing that's on his mind? I think he was a little contentious. I think he was combative where he did not need to be. But I think that every defendant has the right to ask whether or not they have a fair and impartial jurist that they're appearing in front of. And they shouldn't be, degraded because they are concerned about that.
Is denied. You have no supporting data, and you have no idea who I am. That you just pull it out of.
You got the paperwork that I turned in?
I think you're biased.
Did you get the paperwork that I turned in? No.
I'm telling you, that's it. That motion's denied. So we're here today on your motion to suppress.
I think you're biased. Again, no one's brought up race but her.
What is the issue for suppression?
He had no probable cause whatsoever.
Have a seat. We'll go ahead and have that hearing.
Do you want the officer to testify from seated or from up in the here?
I think at the podium.
On a motion to suppress, the issue of probable cause is not the appropriate issue. It's whether or not the evidence was obtained in violation of the Fourth Amendment for a search, in violation of the Fifth and Sixth Amendment for a statement, and in violation of the due process right against suggestive identification procedures.
If you would there, Officer Oliver.
I'm going to skip through this officer's testimony.
I swear from the...
Legally, he's not going to win this motion. He's not going to win it because if the only issue he has is whether or not there's probable cause, the judge won't even legally consider that. That's not for her to consider at this point in time. It's a shame. He needs an attorney, but he doesn't have the right to an attorney. I just think this is so wrong.
At night, did an unattended running car come to your attention?
It did.
Could you describe the car?
I was parked in front of building 102, so the way Promontory is you come up the main hill. There's only one way on, one way off. There's the main office building, which also holds a garage and the laundry facilities, and then there's 20 apartment buildings up there. So I was in front of 102, where I sit for every time I'm on the detail, which I've been on for about 4 or 5 years. As I was sitting there, Mr. Phillips' car, which is a Cadillac, was parked in one of the parking spaces 15, 20 feet behind my car. I had made a stop of a separate vehicle and returned to my position there in the parking lot. As I sat there, Mr. Phillips came down to his vehicle, turned it on, turned his radio on with extremely loud music, and then he left the area and went into building 101, presumably to do something with his laundry.
Would that be any type of
I'm gonna
ordinance?
skip forward.
This was a matter between myself and him, and that no one else was welcome at the investigation. He refused instructions to sit down, to provide his identification, to get off his phone, to do anything whatsoever. Because of his highly agitated state, I awaited a second backup unit prior to making any further actions.
So am I understanding this correctly that he left his car idling while he was taking his laundry inside, and that's the reason for the police interaction? What a great use of police resources.
After several minutes, a Taylor Mill officer finally did arrive. Mr. Phillips had been screaming and yelling to other cars and other people across the complex. I gave him a specific warning.
That would be disorderly conduct. So, legally speaking, there's probable cause so far based on this officer's testimony because the reason for the interaction is the citation for leaving the car idling. And then if the the defendant is yelling and screaming and drawing the attention of people all around, then that would be disorderly conduct, at least probable cause for it. And then the issue at trial is whether or not he's guilty of those things beyond a reasonable doubt. It's such a low standard, right? It just has to be alleging the facts that equal up to the crime.
Warning that if he continued to yell, I would arrest him for disorderly conduct, just as he was bothering the other residents. So Taylor Mill arrived. As he was continuing to be agitated, I detained him in handcuffs to prevent any violence or issues that way. As I did that, a woman who identified herself as Mr. Phillips' wife arrived holding an infant and had a small child with her. The small child ran up to Mr. Phillips as we were in the middle of the investigation. He began shouting about if we murder him. I informed him at that point as he was shouting.
Yeah, I do think the judge could be expressing some type of bias here because there is an undertone of the defendant raising racial bias in his interaction with the police. Are you going to murder me? And things like that. That has undertones of issues with police brutality. And if this judge watching the news thinks that that's overblown or excessive or manipulative, or he's just, another agitator or something like that, it could be the appearance that she's being biased, especially with those unsolicited comments. She could have just said, no, I have no bias against you. I don't know what you mean. And then once she said things about race, I think she should have recused herself because she's the one who brought it up, and race is an undertone of this particular case.
That he was under arrest for disorderly conduct. I was able to identify him finally by the ID card that was in his pocket.
And this is the thing. As stupid as I think that it is to stop someone for leaving their car idling, it's still a traffic citation. The officer has the right to get your identification so that they can write you the citation. I've talked about this in multiple videos before. And if you refuse to give your ID, it can convert from just a citation into a full-blown arrest because they need to bring you in order to identify who you are in order to give you the citation. You don't want to do that. Arrests can lead to violence against the officer, against the driver. It can lead to a myriad of other issues, maybe having to pay bond or something that you couldn't otherwise afford. So it's better to just give your ID over and then fight the ticket in court later if you feel like the ticket was unwarranted, or maybe, the statute says you can't leave it idling for more than a minute and you were only in there for 30 seconds. Like maybe you have an affirmative defense that's really, really good. Don't yell and scream and fight that with the officer in the street. That's why there's going to be probable cause here. Now, the defendant may have something different he's going to say that will magically reveal, not magically, but will reveal that he's not guilty beyond a reasonable doubt, or will reveal that they can't find him guilty beyond a reasonable doubt. But as far as probable cause is concerned, really the court just considers the state's version of events and if it's enough to equal up to the crime.
Do you see Mr. Phillips in the courtroom today?
He's seated to our left.
And the record reflects he's identified the defendant. And what county were you in during this exchange with Mr. Phillips?
Kenton County.
Your Honor, I have no further questions as it relates to suppression.
So, Mr. Phillips, you can ask Officer Ulrich any questions. It's just to the suppression to the probable cause. I'm not trying it today.
You said that when you went back to your vehicle after getting the keys, right?
That's correct.
Did you also drive your car to block the car after you took the keys?
I backed my cruiser up, yes.
Afterwards, right?
After retrieving the keys, that's correct.
What is the procedure when a car is running unattended? Do you run the plates first? What's the procedure?
There's not a specific procedure for that.
Have you done it before?
Yes.
What procedure did you take?
The same thing, I take the keys out of the ignition.
And did you block the car afterwards?
Wasn't attempting to block your vehicle in. The keys were out of it. There was no point in blocking your vehicle in.
So it seems as though he took the keys out of the idling vehicle.
Was simply reorienting my vehicle so that I wouldn't have to get into my car with my back on the vehicle and when you return, to be able to run your information or any of that.
So when did you run the plates?
So I returned to my vehicle, I moved my car back, walked back out of my car to log the tags and radio dispatch, as I said, and that's when I ran. I logged the plates, but I certainly did not run the plates at that point. I wasn't in my car.
So you didn't run the plates? Say what now?
I was out of my car, so I couldn't run the tags and get your information back. I simply logged your license plate number with our dispatcher as that is the vehicle that I am out with.
You logged that afterwards, right?
I'm going to object. The plate issue has nothing to do with reasonable articulable stop.
It's sustained.
Yeah, it's not relevant.
We'll move on, Mr.
What gave you the
Phillips. It has
idea
nothing
that
to
the
do
car
with it.
was running?
I sustained it. You asked questions as to probable
What
cause.
gave you the idea that the car was running?
Extremely loud music, the key in the ignition and the engine running.
How did you know that the key was in the ignition before you went in?
It's a good question because basically, are you entering this car before? Well, now common sense dictates that we all know that you can tell when a car is running from the outside. You can see the exhaust. You can hear it when the engine is on. But did you know that before you reached your hand and incurred into his space in order to seize his property without probable cause or a warrant? I don't know. But either way, if he observes the car idling aside from the issue with the key, the judge is still going to find probable cause.
The car was on.
Were the headlights on?
I don't believe so.
With this car, the headlights must be on for the car to be running.
I may be wrong. I didn't note it. It was still daylight.
I got the body cam. I got the video with me. It shows no headlights on. And with my car, the headlights automatically come on when the car is running.
If you say so.
It's a fact.
Okay.
So
I don't.
So your witness disagrees with you. This is, again, he's pro se. He's representing himself. So I definitely am trying to give him some leeway here, and I think most judges would give him some leeway if he was in front of them. But if an attorney was asking them questions this way, they would be objected to, and the objection would be sustained because he is arguing with the witness. He's arguing with the witness instead of asking the witness questions. You can testify about what your car is like, but your witness has no foundation to know whether or not your car automatically has the lights on if it's running. So, but he is asking relevant questions, at least to probe out that the car was not idling at the time that the officer reached his hand and took the keys out of the car and initiated the interaction with the defendant.
I don't know the specifics of that particular make
maybe
or
I need to
model of
save that
vehicle.
for the trial, then probably. So you're saying that you don't remember seeing no headlights?
That's what I stated.
Okay. Let's see here. Prior to going to the vehicle, have you seen me before?
Yes.
And that day, how many times have you seen me?
That day, I believe you had pulled down in front of Building 101 earlier while I was on the detail, and you had parked there and you were in and out of the laundry room, but I hadn't made any contact with you.
Prior to that day, have you ever encountered me?
Yes.
How many times would you say?
A small number, 2 or 3 times.
2 or 3 times. So with 2 or 3 times encountering me, you telling me that you wouldn't know who I am?
No.
That's a lie.
That's a lie. The judge can determine whether or not it's a lie. Question whether or not it's really something you want the judge to know, that you've had multiple encounters with a police officer, because that can look kind of bad. Like, are you a person that, commits a lot of crimes or something? I'm sure he's trying to say that this officer had it out for him. He knows me. He's had encounters with me. And so he has a motive not to tell the truth about whether or not the vehicle was running. I think that that's really what he's getting to. But that's a risky move.
I can object to his extra explanation on the answers. The answers are what they are. And again, prior contact has nothing to do with
It's really not relevant.
reasonable or typical suspicion or probable.
We'll just deal with this date. This was June 21st.
I didn't hear you.
Your question had nothing to do with probable
I said I didn't hear what
cause.
she just said.
She said
I'm
stick to June
sustaining
21st.
her motion. We'll just deal with June 21st. Any prior contact has nothing to do with this particular incident.
I don't think that's necessary. Okay, so, on one hand, prior contact with the law enforcement officer wouldn't have anything to do with this particular incident of the vehicle idling, and that's what leads to the traffic stop, and then that's what leads to the yelling and screaming and the disorderly conduct charge. However, if you're trying to say this officer has a motive to lie on me because they know me and they don't like me and they've had negative interactions with me before, I think that that's relevant. I think that's relevant, and it goes to bias. And when it comes to bias, you can ask almost anything that you normally wouldn't be able to ask if you're cross-examining on bias. However, he doesn't have an attorney to make that argument for him, so he has lost this line of questioning, which I think is actually a good line of questioning.
Do you have any other questions, sir?
My question is that y'all, no, I don't have a question, I have a statement. Y'all all work together. That's what it's like.
I'm sorry that he feels that way. But what basically you're giving up the arguments that you have because you don't know how to make them, and it's not your fault that you don't know how to make them, but you just don't know how to make them. And so accusing people of all working together, it will cause them to close their ears. The judge in particular, the person that you're upset with the most is the judge who you think is biased. She's the one that you have to sway onto your side to say that there's no probable cause for the charges. So unfortunately, you have to walk that line between, do I want to yell an indictment on the entire criminal justice system, or do I want to win my case? You should really stick to the facts of your case. He was going somewhere with that argument, and I think he just got frustrated and started talking about how everyone's working together. It's a common phrase that people say when they're frustrated with the system, but if they are all working together, you're not getting anywhere by yelling that at them. He's not yelling. By saying that in the middle of your trial or your probable cause proceeding, you should really talk about the facts of your case.
You stopped the car because the car was running, correct?
That's correct.
That's right. Get back on track.
The car wasn't running because it wasn't running. The headlights was not on. So this all is being recorded, correct?
Yes, sir.
All right, that's all I need.
The Commonwealth has no.
So introduce the body camera. If you have dash camera and body camera to show that the car was not running, or maybe another witness to come in and say, I was with him, maybe his child's mother, and the car was not running, that's the better way to go with the argument. You can feel how you want to feel about the situation, but you have to stick to the facts and the law in order to win your case.
Further witnesses.
Okay.
That's a probable.
For the testimony as to both charges, I believe that there's probable cause. If
the testimony, it's no person operating or in charge of a motor vehicle shall be permitted to stand unattended without first stopping the engine, locking the ignition, and removing the key, nor allowed to stand upon any perceptible grade. Doesn't say anything about lights at all. So I think,
Well, that's not the argument. He was saying that the car wasn't running, and he knows it wasn't running because the lights were not on. And you can see that the lights were not on in the video. The judge was going to find probable cause. As I said before, probable cause is just an extremely low standard. I won't belabor it. It just is. And so it's really just a kind of one-sided type of thing. He can make a lot of arguments about bias and things like that at the actual trial, which will be in front of this judge who he thinks is so biased and doesn't like him.
he was actually probably doing you a favor, Mr. Phillips.
he
He
was.
turned it off, and you lose it. You're violating. It's 189.430 subsection 3. Certainly, there was, according to his testimony, is
Can I
no
ask one
probable
more question?
cause to cite you on that.
Can I ask
And
one
then
more question?
also, his testimony was that.
See, listen, you're not, that's the thing, is that you're interrupting and you're not listening. I get that he's agitated, but you have arguments that you're going to need to make. You need to listen to what the judge is saying in order for you to respond to her.
You became very agitated and
Can I ask one more
wanted them to
question?
murder him. So wanted them to murder you. Obviously, and you're screaming and yelling. That's the testimony. As to probable cause, I'm not trying it today. As to probable cause, I find
Can I ask
there's
one more
sufficient
question?
probable cause, and so your motion to suppress is denied. Wednesday, February 13th, and that's at 9 o'clock back here.
February 3rd.
Why doesn't she answer his question?
And I have to caution you, you're going to have to, it's going to be a jury, so you're going to have to know the rules of evidence and,
Oh, so he's going to get a jury trial. Okay, very interesting. So it's not going to be a bench trial. So maybe he stands a bit more of a chance. I don't think he's going to win. But I think he stands a bit more of a chance.
it won't be, you can certainly do pro se. That means you can try it yourself without an attorney. But
I would like to- I got an
you will be
affidavit
held
as well.
to the same standards as everybody else. There will be the rules of evidence. So
I got an affidavit too requesting a lawyer based on my situation.
I'm just.
You're not even looking at it though.
I'm telling you, you have the same. You will be held to the same standard as every other
So
person.
if I have an affidavit, you don't look at it. That's what goes on.
Affidavit for what?
What I just said, I request for an attorney because of my hardship.
Oh, they're not recommending any jail time.
It-
There's certain specifications for a public defender, okay? Which first of all, the case doesn't even rise to a level where a public defender would be appointed.
It's
They're
jail
not
time.
recommending any jail time, and it's a B misdemeanor. So those are cases where a public defender can be appointed is a case where the fine meets or exceeds $500, or there is jail time involved with the charge.
Let me make sure I understand.
But there is jail time involved in the charge. I don't understand that. Well, I don't, and this is not her fault, but this is a question I have, a systemic issue that I have. How is it that even if the prosecution is not offering jail time, they could take that offer away when he goes to trial and he loses, and they can ask for anything up to the 45 days or whatever, or 90 days that he's facing. And just because the prosecution is not asking for jail time, he then can't get a public defender. So all the prosecution has to do is just say, we're not asking for jail time in any case, and then deny defendants and misdemeanors the right to a public defender. That doesn't sound right to me. This state needs to get their legislation together. That does not sound right.
Understand. So
Okay,
you say there's
there.
no jail
And
time
also-
involved in this?
Oh yeah, if that jury recommends 90 days, you're going to jail
Right.
for 90.
So if the jury recommends 90 days and he's going to go, they have jury sentencing. Oh my God. If the jury recommends 90 days, then why is he not entitled to a public defender? If he can go to jail, he should have the right to an attorney. This is ridiculous. How does this stand up under constitutional muster? I don't get it.
So that's why I'm trying to request a lawyer.
No, you have a vehicle. You're not on a disability.
I am disabled.
You are. Yeah.
You're not even looking. I turned the paperwork in, man.
You collect disability?
I turned the paperwork
No.
in.
Do you collect disability?
I turned the paperwork
You're on.
in.
You're on.
If you look at the paperwork, it's going to tell you
Social
that
Security.
answer.
No, you didn't answer me. You do not qualify. They're not
You looked at the
recommending.
paper?
They weren't recommending any jail time. In fact, you are eligible for diversion. You are not eligible for a public defender.
So you're not looking
and that's
at
being
it.
denied.
So you're not gonna
Your
look
jury
at
is scheduled for February 13th at 9 o'clock back here.
All right.
Okay.
Circuit Court.
Better watch out.
Mr. Phillips. I have a tendency to get a little...
Excuse me, ma'am, I didn't hear
That's
you.
it. That's it today.
You better watch out, Mr. Phillips. I have a tendency to get a little what? She's gonna lock him up. Wow. Okay, let's get some background on this, because that's why I can't find any background on it. I don't even know what state this is. If someone knows, comment in this comment section down below, and I'll make an update video on this, because I am absolutely disgusted. I am okay, and I'm also mentally torn, because on some level, the judge made some good points, you know, about statutorily, this is what you're... But I don't think it should be up to the judge whether or not the person gets a public defender appointed to them just because you think he should work. If he's actually not working right now, that means he cannot afford an attorney. Even if he went and got a job tomorrow, which he should do if he's able to, of course. But even if he went and got a job tomorrow, he would not have enough money to hire an attorney unless his first paycheck is in the tens of thousands of dollars, you know, so, and pay his bills. So what are you talking about? I don't understand how he's not eligible for an attorney, but he's not. The judge doesn't think that he is. And that's fine. That's her ruling. And it seems to be that that's what the law is in that state. Kind of, sort of. I don't get it. But he raises some excellent points about this judge seeming to really not like him and not being able to hide it. And she adds the extra cherry on top by bringing race into something where he never mentioned race. And the fact that he was yelling at the police to shoot him and stuff like that is a harbinger of, you know, bad relations and race with law enforcement. And it seems like she read that statement of probable cause or that affidavit, and she felt as though, I'm going to show him, you're going to take this diversion program or you're going to jail. I don't know. I'm really torn on this. I want to know what you guys think. Tell me what you think in the comment section down below. What vibe did you get from the defendant and from the judge? I don't think anyone is 100% right here, but the judge has more of a responsibility, and I don't like that commentary that she was making. It makes me real uncomfortable. All right, I'll talk to you guys later. Bye. Take care of yourselves. Bye.